The Federal Motor Carrier Safety Administration, FMCSA, welcomes you to our webinar on Qualification of Drivers, Vision Standard, Final Rule. I am Angela Wangas from FMCSA's Medical Programs Division and your webinar presenter. Let's take a moment to review our objectives for the webinar, which are to provide an overview so that at the end, the viewer is able to identify important dates in the final rule and their significance, define the applicability of the alternative vision standard, describe the physical qualification process under the alternative vision standard, distinguish roles under the alternative vision standard, identify the 4 parts for physical qualification under the alternative vision standard, identify which individuals are required to complete a road test, and recognize appropriate responses to frequently asked questions about the alternative vision standard. As we begin with the overview, in addition to the content in the webinar, we encourage you to review the final rule on your own in its entirety. The final rule, Qualification of Drivers, Vision Standard, was published by the Federal Motor Carrier Safety Administration on January 21st, 2022, and the Qualification of Drivers, Vision Standard correction was published on February 10th, 2022. Both notices can be found on the Federal Motor Carrier Safety Administration's website at locations listed on the slide. Both have an effective date of March 22nd, 2022. The effective date is the date by which all applicable parties must begin to follow the requirements outlined in the final rule. The compliance date for the final rule is March 22nd, 2023. This is the date by which all applicable parties must comply with the final rule. It is also the date by which all medical examiners' certificates not obtained under the alternative vision standard will become void. Please note that final rule correction notice changed the grandfather provision compliance date from March 22nd, 2022 to March 22nd, 2023 to correct an error in the final rule. The final rule amends the Federal Motor Carrier Safety Regulations to permit individuals with monocular vision to be physically qualified to operate a commercial motor vehicle in interstate commerce under specified conditions. An individual with monocular vision is defined by FMCSA as someone who does not satisfy with the worst eye, either the existing distant visual acuity standard with corrective lenses or the field of vision standard, or both, to be physically qualified to operate a commercial motor vehicle in interstate commerce. Affected parties include all current federal vision exemption holders, prospective federal vision exemption applicants, individuals who were in good standing on March 31st, 1996, after participating in the agency's vision waiver study and are physically qualified under the grandfather provisions in 49 CFR 391.64B. The final rule also applies to medical examiners on FMCSA's National Registry of Certified Medical Examiners who perform physical qualification examinations, as well as to motor carrier employers. To reiterate, all affected parties must begin to comply with the provisions in the final rule beginning on March 22nd, 2022, and meet full compliance no later than March 22nd, 2023. We'd like to share the summary of regulatory changes in the final rule. And as a reminder, the physical qualification standards are found in Section 391 of the Federal Motor Carrier Safety Regulations. The information presented on the next two slides outline the changes in the final rule to Section 391 in the Federal Motor Carrier Safety Regulations. The final rule adopts 391.31, the road test, by adding a requirement for monocular vision individuals to be road tested under certain circumstances. The final rule revises 391.41B10 to read as 391.41B10 lowercase I and lowercase double I. Lowercase double I adds the alternative vision physical qualification under the new 391.44 provision. The final rule revises 391.43B1 to read as licensed ophthalmologist or licensed optometrist may perform the part of the examination that involves visual acuity, field of vision, and recognition of colors. The final rule adds new 391.44 provisions which outline the regulatory requirements in the alternative vision standard, including the new vision evaluation report, Form FMCSA 5871. The final rule amends 391.45 by adding the requirement for individuals physically qualified under the alternative vision standard to be examined and certified every 12 months. It revises 391.51B3 to update the general requirements for the driver qualification files to include road test information related to the alternative vision standard at 391.44. And finally, it amends 391.64B and B4 to indicate that the provisions of 391.41B10 does not apply to drivers granted grandfather rights until March 22nd, 2023, and that after that date, all medical examiner's certificates issued under the grandfather provision are void. Once again, we note that a correction notice was published in the Federal Register on February 10th, 2022, to correct dates in a grandfather provision section from March 22nd, 2022 to March 22nd, 2023, to correct an error in the final rule. As we move into the alternative vision standard requirements, prior to March 22nd, 2022, which is the effective date of the final rule, individuals who did not meet the vision standard in the worst eye were prohibited from driving commercial motor vehicles in interstate commerce unless they obtained an exemption from the Federal Motor Carrier Safety Administration. With updates to the vision standard, medical examiners will now make the qualification determination for individuals who do not satisfy the existing vision standard in the worst eye, rather than referring them to obtain a federal vision exemption. The alternative vision standard implements a collaborative certification process that includes a licensed ophthalmologist or optometrist and the certified medical examiner listed on FMCSA's National Registry of Certified Medical Examiners. As outlined in new Section 391.44, the individual with monocular vision must first obtain a vision evaluation performed by a licensed ophthalmologist or licensed optometrist. It's likely in many instances that the licensed ophthalmologist or optometrist will have treated the individual in the past and may have knowledge of their vision history. However, it is not required by the rule to have a previously established medical treatment relationship with the individual. Consistent with medical practices, the licensed ophthalmologist or optometrist may request that the individual provide previous vision and medical records for review prior to completing the vision evaluation report. The role of the ophthalmologist or optometrist is to provide medical information to the medical examiner for consideration and is not to make a qualification decision. The vision evaluation information must be recorded on the new Vision Evaluation Report, Form MCSA 5871, by the ophthalmologist or optometrist. This form will be discussed in greater detail later in the webinar. Please note that other options, such as statements on letterhead regarding the individual's vision information, is not permitted. Within 45 days of the completion and signing of the Vision Evaluation Report, the individual must provide the Vision Evaluation Report to the certifying medical examiner as part of the physical qualification examination. Under the alternative vision standard, the certifying medical examiner must review and consider the vision evaluation information provided on the Vision Evaluation Report, Form MCSA 5871, and may request additional information to clarify any responses provided before deciding if an individual satisfies the alternative vision standard. The certifying medical examiner must also determine if the individual meets all other physical qualification standards outlined in 391.41B, and if so, may only certify the individual for up to 1 year. The medical examiner should check yes to monocular vision on the Medical Examiner Report Form MCSA 5875. In addition, the medical examiners should not check the box titled "Accompanied by a Federal Vision Waiver or Exemption" on the Medical Examination Report Form MCSA 5875 and the Medical Examiner Certificate Form MCSA 5876. Because the medical examiner is now responsible for making the physical qualification determination under the alternative vision standard, the federal vision exemption program is no longer necessary, and the alternative vision standard replaces the need for a federal vision exemption. We just discussed that the certifying medical examiner is responsible to determine if an individual satisfies the alternative vision standard. In doing so, The medical examiner must be aware that the alternative vision standard consists of 4 separate parts that must be met to qualify an individual under the alternative vision standard. Let's review these 4 parts. The first part is the individual must have in the better eye distant visual acuity of at least 20/40 as measured by the Snellen chart, with or without corrective lenses, and have a field of vision of at least 70 degrees in the horizontal meridian. Number 2, be able to recognize the colors of the traffic signals and devices showing standard red, green, and amber. 3, have a stable vision deficiency. And 4, have had sufficient time pass since the vision deficiency became stable to adapt to and compensate for the change in vision. FMCSA clarifies in the final rule that there must be a period for the individual to adapt to and compensate for the vision loss after the vision deficiency is deemed stable by a medical professional. After reviewing and considering the information presented on the vision evaluation report concerning the stability of the vision deficiency, the medical examiner may use independent medical judgment to request additional or clarifying information from the licensed ophthalmologist or optometrist, issue a qualification for the maximum 12 months or less, or disqualify the individual. So how is stable vision defined? FMCSA did not incorporate a specific definition of stable vision in the final rule. The rule points out that a determination of stable vision is a clinical decision with many variables and requires individualized assessment. Therefore, stable vision is clinically determined by the ophthalmologist or optometrist. The final rule emphasizes that only individuals who are determined to have both a stable vision deficiency and have had sufficient time pass to adapt to and compensate for their vision deficiency will receive medical certification. The vision evaluation report also illustrates this point. So what are the advantages of the alternative vision standard? Ultimately, the alternative vision standard replaces the federal vision exemption program and provides a more streamlined process to medical certification for individuals unable to meet the vision standard due to poor vision in the worst eye. It is a collaborative process that involves both medical specialists, knowledgeable and skilled in vision deficiencies, and medical examiners who are familiar with the duties, responsibilities, and demands of commercial motor vehicle driving. This brings us to the overview of the Vision Evaluation Report, Form MCSA 5871, which is required to be used as part of the physical qualification examination after March 22, 2022, when assessing if an individual meets the alternative vision standard. We have emphasized the advantages of the collaborative approach of the alternative vision standard. Likewise, the vision evaluation report is the tool that facilitates a collaborative exchange of information between the ophthalmologist or optometrist and the medical examiner performing the physical qualification examination. The report provides specialized information that assists the medical examiner in determining whether an individual meets the alternative vision standard. The report provides specific information regarding an individual's vision deficiency and the ophthalmologist or optometrist's opinion related to the stability of the vision deficiency. The vision evaluation report consists of 3 pages. On page 1, at the top right corner, is the Office of Management and Budgets, or OMB, approval number and expiration date of the form. The OMB approval number and OMB approval is required by federal agencies prior to the use of forms that collect information from the public. The Vision Evaluation Report is a fillable form that can be completed and provided to the medical examiner using electronic communication methods such as email or fax. The individual's identifying information, such as name and date of birth, are located at the top of each page. The form features some selections from a drop-down menu to facilitate completion. The section Instructions to the Individual provides information to the individual indicating that the form must be provided to the medical examiner within 45 days of completion. The next section, Instructions to the Ophthalmologist or Optometrist, informs the vision specialist of the purpose of the vision evaluation and points out that their role does not include making a qualification decision. FMCSA's definition of monocular vision and the requirements necessary to meet the alternative vision standard are included as a reference to provide context while performing the vision evaluation, because not every ophthalmologist or optometrist will be familiar with the agency's physical qualification requirements. The bottom of each page includes a paragraph that the report contains sensitive information and instructs on proper handling, disclosure, and disposal of the Vision Evaluation Report, Form FMCSA 5871. On page 2 of the report, questions 1 and 2 asks whether the vision evaluator is an ophthalmologist or optometrist and the date of the vision evaluation being performed. The form is laid out with yes or no responses and provides space for the vision specialist to elaborate as needed. Questions 3 through 5 directly relate to the vision standard requirements concerning distant visual acuity, field of vision, and color vision. Question 6 asks, when was the last comprehensive eye examination? Questions 7, 8, and 9 concern monocular vision. Specifically, those questions ask if the individual has monocular vision as defined by FMCSA, which is on page 1 of the Vision Evaluation Report, what is the cause of the monocular vision, and the date the monocular vision began. It also asks about any current treatment for the condition. Question 10 involves history of any progressive eye conditions, the severity, date of diagnosis, current treatment, and if the condition is stable. The form provides space to enter more than one condition if necessary and continues on to page 3. On page 3, vision questions continue with numbers 11 and 12. These questions request the medical opinion of the ophthalmologist or optometrist concerning whether the individual has a stable vision deficiency and the date the deficiency was considered stable, and if the ophthalmologist or optometrist believes sufficient time has passed since the vision deficiency became stable to allow the individual to adapt to and compensate for the change in vision and to drive a commercial motor vehicle safely. Question 13 asks the vision specialist, in your opinion, is a vision evaluation required more often than annually? Line 14 provides space for any additional comments if necessary. And the final section is the attestation of the ophthalmologist or optometrist that the information provided is true and correct, followed by the date, printed name, credentials, and contact information. Our next section overview is the road test requirement. The road test is another provision of the Alternative Vision Standard. The requirements are found in new 391.44D. The Alternative Vision Standard does not require proof of 3 years of driving experience on public roads as was required in the Federal Vision Exemption Program. A road test is included in the Alternative Vision Standard to ensure that an individual who has been qualified by a medical examiner can operate a commercial motor vehicle safely in interstate commerce with monocular vision. The road test requirement applies to an individual physically qualified under the Alternative Vision Standard for the first time and occurs after being physically qualified by a medical examiner and before driving a commercial motor vehicle. The medical examiner has no part of determining the necessity of a road test or conducting it. The employer is responsible for conducting the road test in line with the provisions of 391.31B through G to the individual physically qualified for the first time under the Alternative Vision Standard. And after successful completion of the road test, the employer must also issue a certificate of driver's road test as outlined in 391.31. Information regarding the specifics of the road test elements and the driver's certificate content is found in these same sections. The final rule points out that employers are already under an obligation to ensure compliance by commercial motor vehicle drivers with other safety regulations. More information is found in 49 CFR 390.11 and 392.1A. The final rule also points out that the road test examiner does not require any specific knowledge concerning the vision deficiency. The road test examiner is to observe and evaluate activities involved in operation of a commercial motor vehicle in the same manner for all drivers requiring a road test to demonstrate that the individual can operate a commercial motor vehicle. There are limited exceptions to the road test for certain individuals. These limited exceptions apply if an individual possessed a valid CDL license or non-CDL license to operate and has 3 years of intrastate or specific accepted interstate driving experience immediately preceding the date of physical qualification under the alternative vision standard. This experience must have occurred with the vision deficiency. These individuals must certify in writing to the motor carrier the date the deficiency began. The motor carrier prepares a written statement to document this information, provides a copy to the individual, and retains the driver's statement and motor carrier statement in the qualification file. Other exceptions include an individual who held a valid vision exemption from the vision standard on the effective date of the final rule, March 22nd, 2022, and an individual medically certified under 391.64B, the grandfather provision. For this last group, the grandfathered drivers, notification to the employer regarding the road test is not required. Before we close, let's examine some frequently asked questions that FMCSA has received since the publication of the final rule. Question 1. Does a medical examiner have discretion to issue a medical examiner's certificate, Form MCSA 5876, for less than the maximum 12-month medical certification period? Yes. Medical examiners may continue to apply medical discretion to issue a medical examiner certificate for less than the maximum medical certification period, which under the alternative vision standard is 12 months. Medical examiners do not have the discretion to issue a medical certificate for more than the maximum 12-month certification period. Question 2. What if the medical examiner does not agree with or has questions about the ophthalmologist or optometrist opinion that the individual's vision deficiency is stable and that sufficient time has passed since the vision deficiency became stable to allow the individual to adapt to and compensate for the change in vision and to drive a commercial motor vehicle safely? Due to the physical qualification determination being an individualized process under the alternative vision standard, if the medical examiner does not agree with or determines that additional information is necessary to make the physical qualification determination, the medical examiner could consult with the ophthalmologist or optometrist for more information on the individual's vision medical history and current status, make a request for other appropriate referrals, or request medical records from the individual's treating provider all with the appropriate consent. The final physical qualification determination rests with the certifying medical examiner who is familiar with the duties, responsibilities, and demands of commercial motor vehicle driving. Question 3. What should be done with each vision evaluation report, Form FMCSA 5871, after a completed physical qualification examination? A copy of each completed vision evaluation report, Form FMCSA 5871, received from each individual seeking physical qualification under the alternative vision standard, must be retained in the individual's medical certification file with the medical examination report form, FMCSA 5875, and the medical examiner's certificate, Form FMCSA 5876, by the medical examiner for 3 years with other relevant physical qualification records per 49 CFR 391.43 HI. The forms are not to be submitted to FMCSA. However, the medical examiner must make all documents and records available within 48 hours after any request from any authorized representative of FMCSA or any authorized federal, state, or local enforcement agency per 49 CFR 391.43 HI. Question 4. Is a written statement from the individual's ophthalmologist or optometrist concerning the vision status sufficient to provide to the medical examiner for the physical qualification examination? No, there is no substitution for the Vision Evaluation Report Form FMCSA 5871. Question 5. After the publication date of January 21st, 2022, and before the effective date of the final rule, March 22nd, 2022, may medical examiners issue a medical examiner's certificate, Form FMCSA 5876, to individuals who have an expiring or expired certificate and hold an unexpired federal vision exemption. The medical examiner may issue a short-term certificate in this situation and must still mark that the individual is qualified only when accompanied by a federal vision exemption on the medical examiner's certificate, Form FMCSA 5876, that is issued. This is because the requirement that an individual is qualified with an exemption is still in place until the effective date of the final rule, March 22nd, 2022. If the medical examiner's certificate, Form FMCSA 5876, expires after the effective date of the final rule and before the compliance date of March 22nd, 2023, and the individual holds an unexpired federal vision exemption, the individual is encouraged to become qualified under the alternative vision standard. FMCSA notes that all federal vision exemptions and all certificates not obtained under the alternative vision standard will be void on March 22nd, 2023. Our final question, question 6. Where in the final rule is the driver required to notify the motor carrier to provide them a road test? Is this information found on the Vision Evaluation Report, Form MCSA 5871. The provisions in 391.44D provides the requirements concerning the individual's responsibility to notify the motor carrier regarding the road test. The Vision Evaluation Report Form, MCSA 5871, provides required information specifically from the ophthalmologist or optometrist and does not concern road test information. This brings us to the conclusion of today's webinar on the final rule, Qualification of Drivers, Vision Standard. We hope that it was informative and that it will be helpful in guiding you through the new provisions in the Alternative Vision Standard. If you have questions regarding the final rule or the webinar, you may contact FMCSA's Medical Programs Division by email at fmcsamedical@dot.gov or by phone at 202-366-4001. Our contact information is also printed on the slide. Once again, thank you for viewing this webinar.